Hello, this is Steve Carlson. I am reading to you now the final set of interrogatories. This one is being served directly on Mark Ritchie, a contestee in a contest against Al Franken and himself for Franken's election and also for the decertification of the Independence Party as a result of that flawed election. So this is the final. I've already presented all of the interrogatories against Al himself or to Al himself, and I've also just presented Nancy Bream, the employee of Mark Ritchie, and also his legal counsel, Bert Blatt. So to Secretary Mark Ritchie, contestee, please take notice that I hereby serve upon you, pursuant to Minnesota Civil Rules of Procedure 33-25 interrogatories. Please answer them as soon as possible, since I want to examine you, Secretary Ritchie, as a witness as part of the trial. Again, that's scheduled December 18th, next Thursday, now is Friday. Now on the blocking claim. 1. Did you or your office talk with the Ramsey County District Court in 2012 regarding the election contest against Betty McCollum they received December 4th, and whether they would allow it to be filed without a fee? 2. Is it your understanding that paying a fee to the Ramsey County District Court is required in order to file the election contest under Chapter 209 Minnesota statutes? 3. Do you think that you, as the state's chief elections officer, should have had an understanding of whether or not a fee was required? 4. Why has your office taken the position that the contest should not have been filed because a filing fee was not paid? 5. Do you believe that under Chapter 209 that the Minnesota Supreme Court should have required the contest to go forward? If your answer is no, because you already sent the election certificate at that time, do you believe this was noncompliance with Minnesota election laws by you? Now here's on the debate claim. As Al Franken has named all these claims, I had grounds 1, 2, 3, and 4. This is what experience in the entertainment business does for you. You're a pretty good communicator, not a great communicator. All right, on a debate claim, number 6. Do you believe the First Amendment of the United States Constitution is part of our elections law in the eyes of the Minnesota legislature, and is that how you applied the elections law? 7. Do you believe First Amendment violations are reviewable under the elections laws established by the legislature, including under Minnesota Statutes 209 and 204B.44? Now on the Caucus claim. Is it true that you require the DFL to file a copy of their Constitution, including the reasonable proportion requirements of Article 3, Section 1 for, quote, outreach and inclusion, unquote? Next, do you personally support this provision and its requirements for some voters being eliminated because of their race or sex? Next, do you ensure compliance of this document and outreach and inclusion practice with the 15th and 19th Amendments of the United States Constitution? 10. As you read the election law, does this DFL constitutional provision, combined with 202A.16 Caucus, who may participate and vote, result in white male voters being barred from voting or abridged in violation of the 15th and 19th Amendments? 11. If white male voters are barred from voting or abridged in violation of the 15th and 19th Amendments, don't you think that as chief elections officer, when this is drawn to your attention, have a responsibility to read the DFL Constitution and work with the legislature and DFL to get compliance with the U.S. Constitution? Now on the email claim, Secretary Ritchie again. Is it true that you took home 600 voter emails from your office? Next, did you take home any other voter emails from your office beside the 600 or so, which your office provided me upon request? Did the 12,000 or so reported to be on your email mailing distribution list contain any email addresses you had taken home previously? So were there more than 600 that he took home? This is back in 2007. Now he finally provided this to me, as they've said in their answer, when I asked for them in October of this last election. I did not have time to use those because I had to spend all my time litigating to get into the debates. 600 email addresses wouldn't really win the U.S. Senate election for the whole state of Minnesota. Next, were you aware before Burt Black intervened to tell Nancy Bream I was not allowed to have the voter email addresses I believed I was requesting on or about October 28, 2012, that Ms. Bream was in your elections office telling candidates that they could purchase all the email addresses and giving them the voter data request form she gave to me and I filled out and returned? 13. Are you sure that none of the voter email addresses you have put in your campaign distribution list, the 12,000 referred to above, are also in the HAVA list you claim I cannot have by law? And 14. Do you believe you have the discretion under Minnesota election laws to give out public information outside the denominated public information section that you're required to provide by Minnesota Statutes 209.091 Subdivision 4? Now, let me just give you a little bit of background as to why I'm asking Mark Ritchie these. Also, we'll address the fact that Al Franken's attorney has said, well, he wasn't familiar, or he didn't have responsibility for all this. Now, I've said he's a member of that party. He's an officer. He's one of the leading officers. He's probably aware of these things. He's supposed to be aware. He's been there practicing these quota endorsement procedures as long as he's been a Democrat. And I believe he is responsible because he is associating with a party that is trampling on the right of association of the party I ran with, the Independence Party, which is now being decertified because of his party's practices. So I think that the Senate, again, should look at this election, how it was conducted, and what part of the results, if any, they would agree with. And it's kind of a sticky wicket. But let me just go through again on the blocking claim. Mark Ritchie, the day after, his office was talking to Ramsey County District Court, more or less, cheering them on as they blocked my elections contest. When I took that to the Supreme Court to try to get it remedied, he was there cheering on the Minnesota Supreme Court not to take any action as far as a contest that was blocked. I, of course, had never brought a 204B.4. I'm sorry. I actually did bring the 204B.44 action after the election when they blocked my contest. It appeared to me that the contest would provide a vehicle whereby these serious, deliberate material violations and irregularities could be reviewed by the Supreme Court. And especially to allow the contest to go on, because they could have. They got it on the 21st, and even though the elections certificate had been wrongfully sent by Mark Ritchie, while blocking, on the other hand, the election contest, knowing that it violated Minnesota law to send that during the pendency of an election contest, only that it needed to be received. It didn't even need to be filed for them to have these responsibilities. But they were cheering them on to block this, and so these issues have never been able to be addressed. And so this is not res judicata. They say it's not justiciable, and none of these courts have ever adjudicated it. And it's been because Mark Ritchie was sitting there blocking it, and Burt Black. On the debate claim, the issue here is whether or not the First Amendment is a part of our regime of election law here in Minnesota, out in the Wild West of election law, I guess the outback of Washington. On the caucus claim, it's clear that forcing me to agree that a majority of women have to make every decision in the DFL is forcing me to adopt a belief which is contrary to my conscience and is contrary to my freedom of political expression and my freedom of political association. I can't associate with these people who come to the DFL caucuses and conventions because I don't agree with this. And the law says you can't participate, but beyond that, your people can't come there and vote for you. The white males are not going to be there to talk with the other people and make the best possible decision for the DFL party and for the state of Minnesota. It's rigged, it's engineered, and this is Al Franken's party, and this is something that is filed with Mark Ritchie. In the past, Mark Ritchie has said, well, I'm just file it. I don't read it. I don't have any power to make sure that we follow the Constitution out here in this here Minnesota. You know, he's from Georgia. Maybe he thinks that here we don't follow the Constitution. And then on the email claim, yes, I found out after he resigned, I saw some Republicans on TV. Somebody told me they were on TV for his job, and they were saying, well, he was disciplined by the legislative audit because he took all these email addresses home himself, and he used them to raise funds for himself and for other Democrats. It was part of a list of 12,000. And I'm asking him, did just the 600 that you admitted to the legislative auditor, were those the only ones? Or did you perhaps have some more in that list of 12,000? I want to get this out. And I also want to know, why was Nancy Bring saying that for years they had sold these to candidates? And all of a sudden, after years of her working there, she still works there, I saw her this year, why all of a sudden is it that I can't have it? It's because I'm out there contradicting Betty McCollum in an election, saying, no, she's not fighting for voting rights. She's conducting a war on voting rights.